with 2 components. The first relates to the role of IEBC and Article 257(4, whether IEBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4 that imposes an obligation on IEBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IEBC was obligated to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation as provided for under Article 10(1) of the Constitution. It is necessary to keep in mind, to keep reminding ourselves that IEBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as the national value and the principle of governance. It follows that IEBC, like all other public bodies, cannot by craft or innovation or interpretation extend its power to include ascertaining whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the 4 corners of their constitutional and statutory mandates. Given this view, unless there is a statutory framework enacted that confers power on IEBC to ascertain whether a promoter has undertaken public participation, the exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining that the amendment bill had met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are 4 stages in the amendment process under the popular initiative route. The initiation stage, that is the collection of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IEBC like it did the 2 popular initiatives dubbed Okoa Kenya and Funguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IEBC, The cost of public participation will be borne by citizens or a group of citizens. In such a context, I'm of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, a timeline of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IEBC, have an obligation to facilitate a broad participatory process that includes voter education. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, Tuyot JA arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons or person who appended their signature in the support of the bill were not aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Dennis Waweru, co-chairperson of the BBI National Secretariat, in his affidavit sworn on February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. He deposed that BBI Task Force Steering Committee and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed to his affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgment. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Waweru, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the Steering Committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting laws to actualize constitutional imperatives. In the end, I hold that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court, filed petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with Sishar and JEN dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandates, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, "Each commission shall consist of at least 3, but not more than 9 members." Section 5(1) of the IEBC Act, which statute, according to its long title, is an act of Parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5(1) appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5(1) of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5(1) of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in registration cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of this court in the case of Hassan Joho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Gatembo, J.A. added a qualifier subject to the nature of the proposed amendments. Musinga J.A. disagreed with the learned judges of the High Court and held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On his part, Tuyot J.A. held that since IEBC had not received the requisites and had not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a court before a party has been subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was yet to be subjected to the county assemblies for debate. This means that IEBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IEBC obligation under Article 257(10) of the Constitution had not arisen. Tuyot J.A. was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277(10) of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are number 1, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10(2)(a) and 89(7)(a) of the Constitution. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining the amendment bill. In addition, there was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake the verification of signatures in support of the amendment bill under Article 257(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on costs, this being a public interest matter, I find each party should bear their own costs of this litigation and also the other courts below. That is my judgment. I will now request the Honorable Justice Ouko to read his judgment.
Thank you, Judge President. This is a summarized version of my judgment. This appeal, consolidating two others, marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 257 of the Constitution. The road traveled by Kenyans since 1991 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, mass actions, and even loss of life. Like the biblical narrow road which leadeth unto life, it was the way, the only way to a new beginning. And so at 10:26 a.m. on Friday, 27th August 2010, with a single stroke of his pen, President Mwai Kibaki endorsed the draft constitution, and there was a dawn of a new era. Before an ecstatic Kenyan people, and as cannons broke into a 21-gun salute, the president released 2 white doves as a sign of peace, love, hope, marking the birth of the Second Republic. Having